we're going to talk to Senator Graham of South Carolina, and I want to talk to him about a few different things. Certainly the topics of the hour, and that has to do with this investigation that's going on concerning Hassan. Secondly, the health care bill, but also what's happening with regard to those detainees in Guantanamo. That situation is more problematic as the events unfold as to what's happening with regard to them. Do we have Senator Graham?
Hello, Fred.
Senator, how you doing?
Good. I'm from the federal government. I'm here to help you and your audience.
Well, I think you're using a federal government telephone system over there.
Yeah, I think
you better enjoy it while you can, because we're getting ready to cut it off.
I tell you what, I think our bill is unpaid.
Well, put it on the tab like
Sal.
everything else. Thank you for coming with us. I know that I'm catching you kind of in between. But 2 or 3 things I want to touch base with you on. First of all, your preliminary assessment of the situation down at Fort Hood. You're an expert on military justice for one thing, and looks like now he's going to get a court-martial, as you said in the very beginning, as opposed to a civilian trial. And what are is it going to be easier or more difficult for him to assert, let's say, an insanity defense in a military tribunal?
Right. It's available to a defendant as it is in civilian court. The standard is fairly close to the federal criminal justice system for an insanity plea. The death penalty is available under military law. You have to prove an aggravating circumstance and premeditation, which I think multiple victims, and it's pretty clear he thought this out. So I would imagine that the prosecutors will present their case to the Article 32 hearing officer, which is a grand jury. That officer will recommend whether or not to make it a capital case, and everything I've seen and heard, I can't imagine that this won't go to a capital case within the military, and he can assert a defense of insanity, but given the facts that I know, it's going to be pretty hard to prove that.
Do you think it'll be tried at Fort Hood? How does that work?
Well, there's a couple things. I've been a defense attorney for many years in the military. You could ask for a change of venue, saying that the community is so traumatized that you could move it to another command. You could even ask for a judge outside the Army, and that would be up to the sitting judge as to whether or not to give a change of venue. But that has been done before, where you could have maybe a Navy or a Air Force judge, but I doubt if that'll happen. But there's probably a good argument to be made to try it somewhere outside of Fort Hood.
Standard of proof the same, beyond a reasonable doubt.
Absolutely. The military justice system I'm very proud of, and that's why I want the military to try terrorism cases. Khalid Sheikh Mohammed should be tried in military court, not given the constitutional rights of an American citizen if he's tried.
All right.
And, but this major will be given a military court-martial with due process rights second to none, in my view.
Well, this will be an example of the military system of justice, and I think people are going to feel good about it when they see it in action, which brings us to our next topic, and that is, what in the world is the administration doing with regard to those Guantanamo detainees now, and are they still pressing to have these people who are actually involved in 9/11 to go through our regular court system?
Well, Fred, I don't know, and I'd like to talk with you more about this. This will probably be one of the most important decisions the nation will make in the war on terror. Remember the 1990 Blind Sheikh trial, the first attempt to blow up the World Trade Center?
Yes, sir.
The Clinton administration, and really the government as a whole, looked at terrorism from a law enforcement perspective, not a military perspective. And the trial in New York, where Judge McCasey was the presiding judge, resulted in discovery requests being granted where the unindicted co-conspirator list was given to the defense. That wound up in caves in Afghanistan, so Al-Qaeda was able to understand who we were watching. And the Judge McCasey wrote an op-ed piece that you've read that says that the civilian courts are not set up to deal with these terrorism cases. Military commissions for 200 years have been the venue we've used to try people for violating the law of war. We can protect classified information in a military commission setting better than a civilian trial. So I would just say this to your listeners. If we criminalize this war a second time and give Khalid Sheikh Mohammed access to our federal courts, not only would we be losing the fact that we're at war, we'd be using the wrong legal system, we would be jeopardizing our national security, and it would be a fundamental major flaw that would haunt this country for decades to come.
Boy, I couldn't agree with you more. And I think that's especially timely because I think that in looking at this situation at Fort Hood, and in looking at what's happening with regard to these detainees now and the decision that you're talking about that's going to be coming down by this administration, the fundamental question is, are we at war or not? Don't you agree with that?
That's it, Fred. I mean, there are people in the administration who agree with me and you. I know they exist, but there are people in the administration that do not buy into the idea that this is war on terrorism. They want to call it overseas operations. They really don't believe that we're at war, and they reject the Bush model of using military legal system. And that's what this is all about. If they give him the same constitutional rights as an American citizen and try somebody else by military commission, you're basically rewarding the guy who perpetrated 9/11 in a way that just makes no sense.
And as you point out, in our regular system, if you treat these fellows like a common burglar or
guy robbed a liquor store,
he's got discovery rights, he's got speedy trial rights, he's got all of these things
he's got Miranda warnings. Now, this is important. Military commissions and military justice is built around the idea of being at war. We don't expect our troopers and Marines to read somebody their Miranda rights when they bust into a door in Afghanistan. In civilian criminal justice system, you have to try someone or let them go. Under military law, you can detain a person as long as you need to if they're part of the enemy force. When you bring them to trial, you allow for military operations to be conducted in a way that will not impede the operations. Under civilian criminal law, there is no planning or concept built around using military force. So it would be a tremendous mistake. Military commissions recognize we're in wartime operations.
Exactly.
Civilian courts don't
Lindsey,
recognize
you know, as I think about it, it would be logically consistent for some in the administration to argue that this Major Hassan at Fort Hood ought to be tried in the civilian court. I mean, why should Khalid Sheikh Mohammed have any rights that he doesn't have?
Well, wouldn't it be odd that a person, in uniform gets a different legal system than a terrorist out of uniform? At the end of the day, the Geneva Convention is designed to protect people who play by the rules. Wouldn't it be odd that you give more rights to someone who plays outside the rules than somebody who is within uniform? That would be unbelievable bastardization of the war we're in. To give the guy who planned 9/11, killed 3,000 Americans, better deal than a military member in uniform captured in a war. It's unbelievable.
Or Hassan, for that matter.
Or Hassan.
He wore the uniform. Lindsey, we're out of time now, and I know you are. I want to get you back to talk about health care later, but thank you for that insight. The American people need to know what's going on here. Appreciate it.
Thank you, Fred. I shall be back.
Thank you very much.